Hello friends, welcome back to the AI Rising podcast. Jayanth, hope you had a lovely weekend. The usual question that I have.
Yes, it was relaxing this weekend. I hope you had a good one too, Leslie.
Oh yes. And today we have a special guest out here with us, NS Nappinai, who is a Supreme Court advocate and founder of CyberSathi. And apart, she also does a lot of social responsibility engagements for training, like training judges, the police forces, the armed forces, students, and even corporate honchos. And of course, more importantly, the reason why we also have her here is because she was part of the AI Rising book. So she contributed a whole chapter. So Napanai, for all our listeners, friend of all, we acknowledge this. We have acknowledged that in the book also, but that was a lovely. I think many people appreciated the point that you gave us. A clear view of what's happening in the space as far as the laws are concerned
Yeah.
and how one should look at policy, etc. So that was, thank you very much once again, a formal thank you.
Thank you so much for having made me part of the book. I thought the topic was fantastic. AI Rising. It's almost reminiscent of all those scary movies and books, etc. So lovely to be here on the podcast too. And I'm a bit surprised that you both had such a relaxed weekend. Considering that you were doing a podcast with a lawyer, at least you should have been there.
Well, I think ChatGPT is creating enough of problems out there. So there are enough
Exactly.
class action suits against ChatGPT. So I don't think you turn your attention to us.
And I
So,
think both Leslie and I have learned that over the years, the amount of pressure you have, the only thing that you can do is relax. Okay, turn off everything and relax.
That's something AI is going to take a long time to learn.
Yeah.
Oh yes.
True.
But so very interestingly, probably because of the nature of the industry itself, the media industry itself, I'm blessed with a lot of lawyer friends, so I have no problem. I think I'm more relaxed with lawyers around, so it's really, I'm grateful for that. Napan, Jayanth and me, we often have this discussion every week before starting, getting into the meat of the podcast. We discuss certain developments that have happened during anything that is striking that you want to highlight as far as the listeners are concerned.
See, we are here to speak about the AI and law. And law is glacial to a very high level. So nothing much happens in a tearing hurry. If you look at some of the developments that have happened over the last couple of years, I would say I can't really speak about immediate,
No, I wasn't.
few.
Napana, this was not about anything immediate. This was anything random. So
Yeah.
this is not even concerned about law. So it need not
Law.
be about a class action suit or anything. Just okay,
Anything that caught your eye.
Yeah,
So
anything that caught
any
your eye.
development around the world that caught your eye.
See,
AI related.
broadly, what I'm seeing is a lot more awareness in terms of AI and what it can do. And also, I am putting my lawyer hat on for this response. And the way I look at it is we are definitely going to have regulations for AI soon, whether we like it or not. So, to a large extent, what I'm seeing is businesses are already gearing up for the possibility of the EU AI Act coming in. So there is a lot of action in terms of consultative processes already in place on that. So that's from an industry perspective. From a safety or a security perspective, the harms that AI can cause and how do you combat it is something that's likely to come up anytime soon. And what I see is I definitely believe that the Digital India Act is likely to address issues such as deep fakes and the crimes that
Yeah.
can be committed using that, and some of the other AI online harms, including possibly, I would say they're not really going too much into profiling there. That may be left more for the Data Protection Act. But as far as Digital India Act is concerned, it is meant to address online harms. And therefore, the way I see it, there is likely to be something coming very soon, which will address the use of artificial intelligence in the commission of crimes. But then going forward, some of the other developments that I have been part of and have been hearing about is the use of AI to fight crimes. And I feel that's a very critical move forward. And I hope that gains a little bit more momentum. And I would love to address a bit more on that and more, more elaborately. And
You actually end Napana, you actually ended up summarizing the entire podcast.
Entire podcast,
What,
exactly.
yeah, because we were just, so we want to build on each of these topics, but more interestingly, okay, so probably let me ask you a slightly different question, because I wanted to first start with more the developments around the world as to okay, the probably the one which I was very keen on asking you is there the Authors Guild filed
Yeah.
a class action suit. I think it was John Grisham, etc. And I'm a fan of John Grisham books, so perhaps that caught my attention because of that. And then Authors Guild has also, periodically been filing these kind of class action suits, saying that OpenAI's ChatGPT, etc. has so they have filed, I think, a class action suit both against the plaintiffs are this thing respondents. I think Microsoft and OpenAI. I think so.
Right.
So that's how it's going to work. Now, these guys are saying that these Chat GPT-4 has lifted, trained on entire books, copyrighted materials, etc. Now we all know how the training has been done. You, as a lawyer, how do you look at all these class action suits, and what do you think will come out of it?
Um, in fact, when you asked me about recent developments, I was consciously keeping away from ChatGPT because otherwise we are generally accused of immediately pouncing on the ChatGPT issues and the various cases that have come up because of that. But the Authors Guild case is very interesting for multiple reasons. Now, when you talk about copyright, what copyright is actually a negative right. It stops anyone except the author from using content unless you have been given the authority to use that content. And copyright laws being fairly archaic and growing over time, they have developed in terms of how you will sell, distribute, hire, or give on hire rather, etc. Right? So the issue about whether using content which is otherwise available to me for uh, training a technology. Is it really covered under copyright becomes one of the issues. But if you take it further and considering that artificial intelligence is trained for the purpose of reproducing that data in a particular form or manner. So, for instance, when you ask AI to write a music score similar to that of Beethoven, then it is obviously drawing from copyright. I mean, of course, Beethoven is beyond the copyright period, so that may
Yeah.
not necessarily be the right example. But I chose that because you already have AI generated
Yeah.
Beethoven equivalent music. So therefore, I use that example. So the issue there will be about similarity. The issue there will be about how much of the copyright protected content is being reproduced by this AI, which has been trained using copyright content. And that's where they have a fairly strong case in that aspect. So, on one hand, we want to enable technology, we want to ensure that innovation is supported, but on the other, you do have certain legal and statutory rights which also need to be protected. So, the way forward for something like this, I would say, is clarity in terms of the extent to which intellectual property rights, because this will transcend copyright going forward. To what extent does intellectual property rights play a role in terms of AI? How do we want to protect it? And can we have a simple process in terms of a licensing through a body instead of individuals, etc., which is how copyright works in any event, right? And also probably rope in compulsory licensing where it's needed, because the idea cannot be to stifle innovation,
Yeah.
but it can happen provided there are checks and balances which balance out and protect both rights. That could be
Yeah,
a
but
way forward.
Yeah.
But I also think, interestingly, I mean, if I'm just looking at it from John Grisham's point of view. Now, if John Grisham were to hold a writing workshop, he would probably charge X amount of money. And I think it's exorbitant sums of money that they would charge for their workshops, writing workshops. Whereas if I put in ChatGPT a prompt saying that let me write, give me a para in John Grisham style, or in Wall Street Journal style, or in Leslie De Monte's, or Jayanth Kolla's, or Nappinai style, it will give it because it's there. So probably, we must look at some kind of payments or something. That is, I
Yeah.
think, what the Royal Authors Guild is driving at. Yeah, Jayant.
Talking of payments and drawing a balance between technology innovation and adoption and privacy, one news article or a headline that caught my attention this morning, in a Financial Times article, is that Meta, the parent company of Facebook, Instagram, and WhatsApp, is readying to charge $14 for every consumer or user in EU, European zone, for using Instagram if EU doesn't allow hyper personalized targeted ads, okay, for the EU consumers. Okay, now this is where are we is this extortion? Is this digital invasion? Are we talking about internet monopoly here? Okay, monopolistic this one. This is straightforward, this big tech company, telling one of the biggest regions and the richest regions in the world, saying that, you either allow me access to profile your consumers and give them targeted ads, hyper-personalized ads, or else I'm going to charge a monthly subscription of $14, right? This headline came out.
They blocked it in Canada also.
Is it? Okay.
Yeah. So I mean, there's a big ruckus going on between Meta and the Canadian government. I know the Canadian government is in the news for very different reasons, but
correct. No, the big tech companies now have gotten to the level of driving their say to the governments. That some of these companies are becoming bigger than the governments and the regulators. So, how is this heading? Purely from a lawyer's point of view, Nappinai, yeah.
In fact, I wrote, I contributed to another book. It was actually Nani Palkiwala's Fest Thrift. And in that, I took exactly this issue as the basic premise about how social media platforms are assuming to be sovereigns. And I have evaluated, are they really sovereigns? Because, if you look at the characteristics of a sovereign, you would see that most of the characteristics may actually, fall in place for a social media platform.
Right.
But ultimately, the whole issue about the primary issue of the identity of a sovereign being a recognized legal entity will never be part of a social media platform's characteristic. So ultimately, whatever they may do, however big they may be, and if you look at where they are really drawing their strength from, it is the strength of the netizens. It is the strength of those persons who form part of a particular platform, which the platform then starts treating as if they're all citizens of that platform.
That's a good point.
So they start getting these grandeurs of sovereignty.
United States of Facebook, United States of Google. Yeah.
Yes. So the real issue is that when it comes to regulation, when it comes to what is it that you're going to do a face-off on, we have had a lot of face-offs too in India, and primarily you've seen that it's been mostly Twitter versus the government, etc.
Right.
But when you look at all of these face-offs, it'll all end in only one way. Ultimately, if you're the target is to have the largest possible audience or the largest user base, you cannot start putting down extortionist or usurious terms, which will then impact your user base itself. Having said that, if an entity wants to charge for a commercial service, nothing in law really stops them. Right. Nobody says a social media platform has to continue to give its services for free.
For free. Yeah.
So that's where the balance really will be. that if social media platforms decide to charge, the issue is not about them trying to do a face off with government or the regulations that have emanated from a particular territory. The real issue that is likely to impact them is how indispensable are they, and to what extent is a user base going to start believing that this is indispensable. And I would give one example to close out on this. What happened in India and WhatsApp? If you remember, before the changes happened to the intermediary guidelines,
Right.
happened in 2021, way before that, when WhatsApp decided to change its privacy settings.
Yeah, I remember that. Yes.
Not giving the same opt out for India as they are doing for EU, for instance. Everyone stood up to WhatsApp and said, sorry, we have alternatives.
Yeah.
All of us did that, right? We moved out, or we started creating our
Signal and Telegram. Yeah.
Yes, exactly. And then WhatsApp made a statement in court saying they will continue to have this pop up for accepting their new privacy policy, but they will not stop the service to those who refuse to accept the new privacy policy. And that still continues. We now have the Personal Data Protection Act in India. We'll have to wait and see how it is going to pan out, because you still have to get the rules under that to have better clarity. I personally feel that we are a little weak in the law with respect to the opt-out equivalent of EU. But having said that, maybe we are going likely to get a little better protection through the rules. We'll have to wait and see on that.
No, I'm glad you brought
I
up
gave
this.
the WhatsApp example is to say that everybody understands, when it comes to business, you want to charge it's absolutely within your right to charge, but be ready to lose your user base.
User
And
base.
that is what will create the dynamics in terms of free or freemium.
But Nappinai, I mean, you have a point here clearly, and I think we all subscribe to that view, which we have done in the past also. Basically, that of creating alternatives, options, social media, whether it's Signal, whether it's Telegram, or whichever it be. But it's easier said than done sometimes when you look at it. Now, for instance, the first mover's advantage in these particular cases has remained. If you're used to, having your friends on Facebook, I mean, the network effects always work. I mean, in most cases, at least, there are clearly exceptions to the rule. But the reason why I brought up this topic is because I'm connecting it to the data protection bill. Now, if you look at the Meta announcements recently, and you look at Microsoft announcements, Microsoft is having the Copilot across all its offerings. Similarly, Meta is doing a very similar thing across all. Now, if you look at Threads, for instance, Threads is just a replica of Instagram. I don't know, it's as I would say as distasteful as
Twitter. You mean?
Huh?
Twitter.
No, Threads.
Yes. No, Threads is
Metas. Metas.
You said
so
Threads is the
Threads,
replica of Twitter, not Instagram.
No, I'm saying. Sorry. Yeah, but I'm saying it's as distasteful or as the thing as Instagram, perhaps. So Instagram at least has a different kind of. But here's whether you want to call it a replica, whether you want to call it anything, it's hardly anything like X or Twitter.
Like X,
we should be calling it X now. I don't know how X and post and tweet, and Musk has made it really tough for all of us. But given the kind of, I think as it is, AI has got this potential of connecting the dots so much better than most of us, and which is why it excels in all the stuff. Social media has been doing the same. Is this data protection bill going to find it increasingly difficult to tackle these kind of situations?
Well, you've had the GDPR now for how long, right? It was introduced in 2016, and then it became effective from 2018. It was a 2-year window, right? So from 2018 till date, are you seeing a reduction in terms of profiling? Are you seeing a reduction really in terms of targeted marketing? So we have not yet got that, and we have to still wait to see how the Data Protection Act is going to be implemented. The indication has been a 6-month window for it to be implemented.
Hmm.
And that would also then require the rules to be notified before then. And then there may be some timeline or a window for uh, the implementation processes for businesses thereafter. But effectively, what the businesses have been told is get started right away.
Hmm.
Right? So, given all this, I would only say this. One, the law hopefully will act as a deterrent. It may not necessarily take away all forms of profiling. I was very happy, however, to see that India's Data Protection Act does not use the word profiling, unlike EU's GDPR.
Right.
That was, in fact, something which formed part of my report against the 2022. I won't say against, in terms of the 2022 draft. And I was very happy to see the final draft did not have the word profiling, because by using the word profiling and then using the object which is for protecting individual privacy and rights, as also to enable businesses, effectively you are giving a certification or a legitimacy for profiling. And
Hmm.
therefore, not using that word and making it very clear that it's talking about processing, there was a critical move that India has done. So, what I would say is this: law at any point of time can only be at best a deterrent, and where a violation happens, if it is provided for in the Act, then the punitive remedies kick in. How effective a deterrent a law will be decided by how effective the implementation of the punitive measures are. So, if
Right.
a particular jurisdiction is shown to not be that good in implementing what the threat of a punitive action is, then the law is very weak and it becomes a paper tiger. So we
Hmm.
have to see. EU has actually held, it has shown a fairly strong hand when it came to violations, and that's how they have actually been able to at least deter to some extent. So we'll have to wait and see whether India will be able to measure up to a similar threshold or even better, hopefully.
But one of the counter arguments in this particular case, I don't think, I mean, there's obviously lots of nuances to it, but one of the counter arguments that I've seen is basically that we share willingly a lot of data with the US borders, for instance, or in India borders. So whenever we're, like, say, when you apply for a visa or you apply for immigration or anything across anything, we have provided practically every amount of data, whether we're doing it to insurance bodies, whether you're doing it for the bank account, whether you're doing now, if we are doing all that kind of stuff, it's already there, and unfortunately, that gets into the public domain at times. Um, how effective can these laws, really be? I mean, yes, we require these laws clearly, and there have to be, these guardrails around it. But from a practical point of view, what would you like to say to people who provide these kind of counter arguments?
The first thing I want to point out is the weakest link in India's Data Protection Act is that it excludes data voluntarily shared by a user on online. So
Hmm.
that includes voluntary shares on social media also. In fact, that's one of the illustrations that they've given.
Right.
According to me, that is the weakest possible. It
Hmm.
weakens the act so much,
Correct.
according to
Correct.
me. That's something that could not have been an exception to a Data Protection Act.
Yeah.
Voluntary
because
sharing is
because an
very
average
easy.
an average citizen does not know what his data is and how is it being used, and that education of privacy itself is a long way to go, an average internet
Exactly.
user. Yeah.
And the reason why I use this is ultimately, wherever you're sharing data, purpose limitation is what is likely to work best for you. So, for instance, we have had these problems also in India. You don't have a choice but to submit all kinds of personal data that the government is asking for if you are to receive your driving license. You don't have a choice because it's only the government authority which can give you the driving license. And there was a period when this data was being commercially utilized, meaning the government authority was selling this data. When there was a protest against that, then they stopped. But what about the several million data sets that were already sold? There
Mm.
was no pullback. There was a clear decision in the Aadhaar case in terms of what can be done and what cannot be done, particularly the data and biometrics that were being collected by private entities. So certain provisions were struck down. And yet, there was nothing in the judgment about a pullback, about deletion in terms of data already shared. So we have to be a little bit more conscious in terms of understanding one, what is the purpose for which I'm sharing data? If it is for a governance purpose, that's why the purpose limitation stops. You cannot use it beyond that governance aspect for which you took that data. If it is to give me a driving license, that's it, period. You cannot share it beyond that. Similarly, if it is social media, there also a purpose limitation is what would have really protected us. If it is any other kind of sharing with a private entity, again, we need guardrails everywhere. And ultimately, I personally feel implementing purpose limitation very stringently, enforcing against sharing or utilization of data beyond that purpose, not allowing someone to use beyond that is too critical. And that's where I feel our new act has fallen a little short too on that.
But it,
We could have
just as I'm
addressed
thinking,
better.
I'm just thinking aloud. Basically, but the Aadhaar has done exactly that. It has connected all those databases. So I mean, where does the purpose limitation stand out there? I mean, we could have brought up these points even at that point. I mean, we did bring it up. I'm sure a lot of these
No,
arguments were
that was
there.
the part which the Aadhaar judgment, the Puttaswamy judgment struck the
Yeah,
part down, that you cannot have these linkings of multiple silos. But the problem is, and if you look at what happened after the Puttaswamy judgment with the amendment to the Aadhaar Act, etc., is that they said that Aadhaar cannot be the sole identity document. It can be one of those. Voluntarily, you can rely on it.
yeah,
And
but we know the practical.
let me just complete. See, that's where the problem is. On one hand, you made it mandatory for linking PAN card and Aadhaar. So if you are a taxpayer, then you're going to be punished for it because you're going to then be made to link this for as a mandatory thing. So you already had the first level in terms of dilution of user rights there. And then you give this option saying it's voluntary usage if you want. You have already socially engineered people to start using Aadhaar as the identity document. It then just becomes, I always say the opposite or the real risk of privacy is not surveillance, it is convenience. So, for the sake of convenience, we ourselves sometimes end up diluting our rights. And that's what the ecosystem takes advantage of. And
This is
that's
that
why I
frog
think
in
purpose limitation will help, because if you are going to limit it, saying you will use it only for this and then you will delete this data, then this whole over the top obsession that corporates and even governments have gotten into in terms of collecting our personal data will then automatically get reduced.
This is that frog in the well approach. They do it very, very slowly. So you don't, if you put the frog directly in the boiling water, you're going to have a big problem out there. But yeah, I mean, and it sounds like an
I
oxymoron,
know,
no? With
I
the
feel
kind
like
of,
we're all the frogs in that boiling water.
I
we
mean,
all are, we all.
like they say, you give them an inch, they'll take a mile, but they'll take that mile 1 inch at a time. Okay.
True. Segueing back, I mean, a logical segue is into the Digital India Act now. Now, in the Digital India Act, I think something similar is happening. I mean, of course, all my discussions with all the government officials on the record, off the record, etc., give me a clear indication that we do not really have a very strong view on how we are going to regulate AI. I mean, it's all in bits and pieces. Okay, let's see how it grow. Let it grow first. The kind of messages that I'm getting, if I'm just trying to paraphrase some of these discussions. So the feeling, I mean, clearly if I were to summarize it, it's okay, let, AI first
Evolve and
help
get ready.
evolve, let it help companies, then we
Yeah,
will see about the laws. Now, I'm
correct.
not too sure whether that approach is really going to be a very sensible one in the long term, because, again, it will become the same. It's like Aadhaar. Then, the horses would have bolted out of the stable, and then we try, to rein in each one of them over there. So,
We
any
are,
one of you.
yeah, yeah. We are actually caught between a rock and a hard place every time when it comes to technology innovation, business
Correct.
opportunity, and regulation.
Yeah.
So, the only way I can look at whenever I talk about technology or emerging technologies, to be more precise, I personally feel that we need a mental or a mindset change. We have to assume and understand that law is supposed to be an enabler. We are still thinking in a very old fashioned way that law is a stumbling block. I still remember early days as a litigator, whenever a client would come, particularly a corporate client, they will always approach a lawyer with trepidation, with fear, and they will say, but ma'am, you will always just tell us, why did you do this, why did you do that, you shouldn't have done it, etc. And their whole attitude would be that a lawyer is always an obstacle, and therefore equivalent is law is an obstacle, and when we have no laws, we are better off. So if a lawmaker starts thinking like that or keeps thinking like that, then when are they going to come out with laws which will become enablers? And that's why I'm saying, as a policymaker, you must have a mindset change. And once you do that, then you will figure out how you can have law as an enabler, and then put checks and balances to make sure that this enabling is not going to go overboard. There will be some protective measures that you will innovate. You will use all these technologies to create new things and to probably improve the quality of life of people around you. But you will do so cautiously, you will do it responsibly, and you will do it with the checks and balances that the regulation puts in. If you don't have all this, what do you really have today? An unfettered wild, wild west where
Yeah.
everything will go on. And then, as you said, Leslie, after the horse bolts, we'll then run behind it trying to figure out how can we try and protect ourselves and others around us. How does it really help? So if I personally feel that we don't have to go overboard. If you start thinking about all the complexities of AI, particularly explainable AI, etc.,
Right.
then you may meet that stumbling block in terms of how do I create laws around this?
Yeah.
Is this even going to be feasible? Because one of the fundamental rules in terms of lawmaking is you will only make laws which can be enforced. If you
Hmm.
can't really
Yeah.
enforce it, then what exactly are you going to be regulating, right? So therefore, I can understand that it can't comprise everything that any particular technology, particularly AI, will throw at you. Having said that, you already know certain aspects of AI which need regulation,
Yeah. Yeah.
and you have to provide that ring fencing for those particular identified threats or weaknesses which you can regulate.
Do
Right.
you see that happening in the Digital India Act?
I hope so. I am not privy to what is there in the Digital India Act. But then, if you look at their presentation and if you have heard the minister in terms of all the public consultations that he has had, he has specifically talked about regulating AI in the context of online harms. So we talked in the opening statement about deep fakes. I would
Yeah.
think deep fakes would definitely form part of online harm, and therefore there should be a provision in the Digital India Act that may combat that. Well, having said that, I would still bat for a more technology neutral law rather than technology specific when it comes to criminal provisions.
Right.
Because
Hmm.
today you have deep fakes, tomorrow it may be something else. If you remember, early days we had imagery, which
Hmm.
was actually of the person. Then you have morphed pictures. Then you now have deep fakes. You
Yeah.
will have something even more than this.
Correct.
So we must have a provision which is dynamic enough, which is specific in terms of what it is making a criminal offense, but dynamic enough that if you find a new way to create something that's going to harm me, even that is captured. So that's what I would bat for. we'll have to wait and watch to see what the ministry is going to come out with.
Nappinai, as a follow-up to that, and as a follow-up to what Leslie said, I mean, Indian government, as a part of Digital India Act, considers AI evolution and government itself as a kinetic enabler, in their words, and they feel that the market is not ready for stringent regulation, right? But with emerging technologies such as AI, wherein they're evolving very fast, Leslie and I talk about AI 1.0, and after the generative AI came in, AI 2.0 has come in. The regulations or the lawmaking, or the people who are making the laws, okay, they also need to, practically speaking, they need to keep up, and the laws or the policies or the regulations that ought to come up, they need to keep evolving along with the technologies. Now, in the case of AI, that could be every year per se. Then in which case we are talking about like software release versions, we might have policy AI Act versions. But you started the conversation saying that in the case of AI and law, over the years, nothing moves. How practical is it that people who are making laws, regulations, and policies for emerging technologies practically keep up with it, and every periodically they bring in new sets of guardrails and ring fencing? Is that practical at all?
Yeah, very interesting question, Jayanth, and it's actually happening in a lot of ways. So if you look at the global scenarios, invariably, whenever it talks about strategy documents, so you've had white papers released by government agencies. These are all non-binding white papers, including if you look at the US recently. Interestingly, they call it, the AI Bill of Rights. I
Right.
found the name very interesting because they are equating your rights with respect to AI on par with fundamental rights then.
Correct.
So, if you look at all these jurisdictions, UK has come out recently with one. Why India itself, it had a white paper, I think in 2018,
Yeah.
but we have had two more white papers in part one and part two for AI from Niti Aayog.
Right.
So more recently, you've had these kind of evolutionary process in terms of strategy documents over a period of time.
Yeah.
Interestingly, EU is the only one which has moved from that strategy or a policy document to a draft law, which will be the regional soft law from EU, but
Right.
which will then be adapted by the EU states. So I'm waiting to see how far the EU AI Act is going to have an impact, not only in terms of EU, but also with respect to other regions. Because again, if you're going to have an AI Act which is going to mandate certain kinds of prescriptive provisions,
Right.
which is what they are saying. So, for instance, they are going on a risk-based segregation.
Yeah.
So, when they're doing that and they're saying for low risk or limited risk, it's only a regulatory framework and transparency and disclosures, etc. Again, just like digital personal data protection laws, you may not have harmony across multiple jurisdictions otherwise. So you're then calling upon businesses to comply with fairly stringent or extensive prescriptive or regulatory provisions, and you'll have nothing in the rest of the world. So how does it really help innovation anywhere else? So I'm really keenly watching the developments in terms of the EU AI Act, because firstly, look at how much time it's taken even within that region.
True.
And they're saying it is still going to take a little bit more time for all the EU nations to negotiate and come to a consensus.
Yeah.
Yeah,
So
and sometimes when I look at it,
for that region, then imagine across the world.
yeah, but Nappinai, even if you look at the crypto, the currency, the kind of stuff, we went gaga over blockchain, which rightly so. I mean, it was the underlying technology. We got lost over cryptocurrency, or as far as the rules are concerned and all. And I think as of now, I think it's a total mess. Nobody really knows what's happening out there, and probably I think people have even stopped caring about it in most.
No, that's because CBDCs are coming off the edge. So
yeah. No, but even
That's primarily it.
yeah, I'm just saying, but the point is like, as far as cryptos are concerned, the kind of hype that we had and,
Has died down,
the
yes.
corruption, it's completely tossed up as far as the laws are concerned around cryptos. I think it's still nebulous, right, Nappinai, as of now? We still don't know what's happening. We still don't know what's happening on
Yeah,
the,
there has
as
been
far
a
as,
lot of there's been a lot of development. You have MICA in the EU now, so
yes.
you do have some movement. But ultimately, when you look at regulating cryptos, on one hand, I really fail to understand why it has to be that difficult. Again, if you're going to look at all or nothing, then you'll get no laws. If you start small and you start deciding, okay, these are the issues that we need to address, and we will regulate certain aspects of it, particularly the kind of speculative investments and volatility that has impacted so many people. People have lost their life savings on
Yeah.
these kind of
Yeah.
speculative investments without even knowing what crypto is. I still remember I did probably the one of the first sessions in India and on crypto when people did not know what crypto was about. This was early 2017.
Mm.
And I had a huge line of people waiting after my session asking me, Madam, you know that round gold coin with that B put on it?
Be
Is
put on.
that what cryptocurrency is? See, that was the level of awareness, and I don't see it any better many years down the line.
Down. Yeah, true.
And how many people even understand what is an NFT?
Yeah.
And you have kids investing in it. So that's another hype which has already died, but it is not really dead. It
Mm.
is there, it is happening, and it is something that needs regulation and soon. So, what I'm seeing is many jurisdictions, particularly the smaller countries, are looking at it as a cash cow. So, they
Mm.
are just taking the benefit of it without really worrying too much about the consequences. But we are a large country, almost a subcontinent, right? So we cannot take these kind of risks and just sitting back and waiting to see where the world is going and where should we head, etc. There are simple, small steps we can take, and I really wish policy will start thinking like that. Instead of thinking all or nothing, we have to start dealing with some of the smaller issues in terms of what do you want to permit, or at least what do you want to ban or stop.
Right.
No, but that's exactly the point that I was driving at, because cryptocurrency is a fairly, I mean, if you compare it to the kind of complexity around AI, crypto is not that complex. So it's much easier to, as you said, a step by step, a piecemeal kind of approach and get it done and out of the way so that there's some clarity around it. Of course, there's the taxation and all, but as I said, from the law perspective, I'm glad you clarified those points.
Yeah, so one
But
more thing I just wanted to clarify because Jayanth raised it. CBDTs are not really
CBDCs. Yeah.
cryptos in that
CBDC,
Yeah. Yeah. Yeah.
because they are just digitized forms of
yeah.
fiat currencies.
Fiat
They
currencies.
stand on a
Correct.
completely different footing.
And
Maybe,
that comes under the RBI anyway. So
yeah.
Yeah.
that's
So
Exactly.
merely because a nation may want to come out with CBDCs, it doesn't stop them from regulating other kinds of private cryptos.
True. True. No, what I
and
meant
that's
was
a form.
from the point of
That's a form of currency anyway.
yeah, from the point of investment point of view, CBDCs are also backed by some kind of a underlying blockchain technology, and some sovereigns, some countries are making CBDCs tradable or investable. Okay, and that's where some of the investor, or at least the mature and the serious investor money is heading to. That's what I was
Anyway.
trying. Yeah.
I mean, obviously, these kind of topics, I mean, we can talk till the cows come home. But before we wind up the session, love your thoughts on your favorite subject, cybercrimes. Now, given the kind of sophistication that we have both in AI, you did touch upon deepfakes and other kind of profiling that is being done, but the level of sophistication it cuts both ways. Hackers are using AI to hack into this, and always trying to stay a step ahead of these cybercrime. As far as the security is concerned, and security firms are also trying to counter this, but I mean, it was always the Tom and Jerry kind of a cat and mouse game that we have. So you wanted to share your thoughts specifically on that, so I'd love
Yeah,
to
so
hear
there
from
were,
you.
yeah, yeah. So there are two aspects to this which I wanted to share, and thanks, Leslie, for the question, therefore. The first and foremost is combating crimes which are cyber crimes per se, and those which use AI for an enhanced version of cybercrime. So there we need, there is already a need felt that the Information Technology Act and the limited provisions under that are not sufficient, and therefore the possibility is that the Digital India Act may provide for certain, additional or much wider amplitude of provisions to combat cyber crimes. We'll have to wait and watch to see what we are going to get. In the meantime, one of the surprise developments that happened in India was that a new alternative to a more than 100-year-old code was proposed, which is the
Yeah.
Indian Penal Code is likely to be replaced by the Bharatiya Nyaya Sanhita. It took me a long time as a South Indian to learn that name by the way. So, so there is a high possibility that you may have provisions under that new code also, which may combat cyber crimes. See, but
Mm.
ultimately, this is my concern. One, do we need more provisions? Of course, we do need more provisions. Can those provisions be targeted towards combating AI-enabled crime? Certainly, they can and they should. But what do we need the most? We may have had limited provisions under the Information Technology Act. How much or how well was it implemented or
Mm.
enforced?
Mm.
Ultimately, whatever law you bring out, when you go to grassroots, you're going to have a village SHO or a station house officer, as we call it, okay, in law. That's the person who is going to be implementing that law. So the law has to be simple and easy for him to understand what it applies to and what it doesn't, and be able to implement. See, we can talk about AI at a very high level, but we have to ensure it trickles down to protect the end user, and that
Mm.
end user is a very simple person, probably in a village. So we have to take this socio-economic situation in mind when we are formulating laws. The other aspect of it, which I really have been batting for many years now, is to use artificial intelligence, to use technology to combat crimes.
Mm.
So one of the things that happened was I had proposed this, in fact, in February 2017, and after which I was appointed as amicus curiae in a matter which was dealing with child sexual abuse content online and violent imagery of women online. So the whole proposal was that artificial intelligence can be deployed at the stage when somebody is trying to upload content and before
Mm.
it hits the public, to root out this kind of content. So India actually took the lead in terms of trying to figure out technology-enabled processes for protecting women and children online. The Supreme Court made it an order of court, and whenever a Supreme Court passes an order, it becomes the law of the land. So it had appointed a committee, and all the consensus proposals of the committee were made an order of court, and one of it included development of AI technology for this purpose, for deploying real time. We are talking about February 2017 to October 2017. And if you fast forward to today, you'll see that this kind of AI technology is already being deployed.
Yeah.
Nowadays all the platforms have to file their reports
Right.
online, the safety reports, etc.
Right.
So when you look at
Yeah.
those reports, you'll see specific reference to this kind of technology being utilized not just for protecting women and children, but also to combat fake news and hate speech, etc. So I feel that we have to learn to use technology in a positive way also. We are not only talking about the negatives or the threats that technology can pose. There is so much of positive outcomes that can come with using technology well. We can't get scared of technology, we cannot eschew technology, we can't run away from it. It's there in our lives. So we have to learn to use it better, and we have to also see how we, when I say we, I mean you could be the government, you could be the law enforcement agency, you could be a user, you could be a corporate entity, etc. each one of us have to see responsibly how we can use technology as a protective or a preventive measure also.
No, I'm glad you brought up all these topics because I think the take home for today, for this podcast, is basically that I think for our listeners also is that you should look at law as an enabler, not as a stifler of innovation. I
Correct.
think if you think it more from this particular point of view, life would be easier. That the lawyers are not here to, stifle innovation, but help us understand it better and protect our own laws. So, Nappinai, wonderful having you on this
Yeah.
podcast. And this is not the first and the last one that we are there. We're going to see more of you on this podcast as usual. And
Yes.
thank you once again for also being part of the book. And Jayanth, thanks as usual. See you next week, bro.
See you next week, Leslie. And Nappinai, thanks a lot. It's been a pleasure.
Thank you so much. Lovely to have been here on this podcast. And of course, as I said earlier, it was my pleasure being part of the book, Leslie and Jayanth.
Thank you very much.